Good morning, everyone, and welcome to the Ontario College of Teachers GoToWebinar session regarding an employer's duty to report. My name is Kathy Anstadt, and I'm an External Relations Officer here at the college. Before we begin, I'd just like to go over a few housekeeping items. You'll note when you joined the webinar that your audio was automatically muted, but we invite you to ask questions at any time by typing in your question in the questions box in your control panel. And our staff will stay online as long as necessary at the conclusion of the webinar to ensure all of your questions have been answered. You can download the PowerPoint we'll be presenting today. Just click on the Handouts tab in your control panel and follow the instructions. And if you experience any technical difficulties during the session, please contact GoToWebinar technical support at 1-877-582-7011. And to begin, I would like to now introduce Michael Salvatore, the CEO and Registrar of the College, to start the webinar.
Thank you, Kathy, and good morning, bonjour, everyone, and thanks very much for joining us for this college webinar. We're delighted that you are interested and hope that you find the webinar useful to you. As you may know, we engaged recently in a strategic planning exercise with our council, and one of our strategic priorities is stakeholder engagement, and so we're counting this as one of those means that we can engage with some of our stakeholders, our important stakeholders. We also have an obligation to transparency and accountability, another of our strategic priorities, and so we hope to shed some light on some of our practices for you today and to answer your questions. We have a number of presenters from our Investigations and Hearings department that will be sharing with you some information and answering your questions. Chantal Bellil is our Director of Investigations and Hearings, who I think is going to start things off. We also have Janice Duggan, our Manager of Investigations, Adele De Silva, an investigator, Jeff Steinberg, one of our investigators, and Patrick Winter, an Intake and Hearings Officer. For those of you that may have taken part in our webinar last year, some of the information may appear similar. However, we've also added some new content relating to fitness to practice issues. Our staff, all of us, will be available at the conclusion of our webinar today to answer any questions that you may have. And in addition, the information presented to you today will also be available on our website. So again, welcome and thank you for your interest, and let's get started.
So we'll invite Adele and Jeff to start us off. Thanks.
Thank you, Michael and Chantal. The next few slides set out the statutory framework which governs your reporting obligations to the college and is a review of what we provided at our webinar last year. Such duties include an ongoing obligation to provide documentation, information to the college within specified timeframes. In 2018, the college received nearly 400 reports from employers under Section 43.2 and 43.3 of the Ontario College of Teachers Act. Please direct your attention to the slide on the screen. If you terminate, suspend, or restrict the duties of a college member for reasons of professional misconduct, you must notify the college in writing within 30 days. You must report even if the member resigns while you are conducting an investigation or compiling evidence or information. We all know what constitutes a termination or suspension. However, it may be less clear what constitutes a restriction of duties. Jeff, would you like to provide a few examples?
Well, Adele, some examples of restrictions may include removing a member from an occasional teacher list, an administrative transfer of a member to another school for disciplinary reasons, and blocking a member from teaching specific grades or courses.
I don't know if any of our participants have had this issue come up. If you have had any questions, please feel free to send your questions to our questions tab, and we'll attempt to answer them now or at the end of the webinar. Section 43.3 is self-explanatory and sets out various scenarios relating to duty to report as they relate to certain types of criminal convictions. Section 43.3 states that if an employee or a former employee is charged with or convicted of a criminal offense involving sexual conduct and minors, or an offense that in the opinion of the employer indicates that students may be at risk of harm or injury, the matter must be reported to the college within 30 days.
Adele, did you say that former employees are also included as part of this reporting obligation?
Yes, absolutely. This requirement also applies to former employees.
Section 43.3 also contains a catch-all provision. If you are in doubt, report. Section 43.3 of the Ontario College of Teachers Act states, if a member has engaged in conduct or taken action that, in your opinion, should be reviewed by a committee of the college, you should submit a report. In addition, you are obligated to provide a copy of the notification letter to the member at the same time you notify the college. Please note that the college has been asked in the past whether it notifies employers of public complaints. Under the Act, the college is only required to report the outcome of investigations to you. In most cases, where matters are fully investigated, the college will request information from you, and in so doing, you will become aware of public complaints against members at an earlier stage in the process. Section 277.40 of the Education Act triggers the duty to report in relation to teacher performance appraisals, TPAs, or member resignations while on review status during the TPA process. Now we are going to review some of the information that should be included in an employer report. What should a report include? The member's name and college registration number, a summary of events that led to the report, specifics of disciplinary action taken by the employer. It is important to provide sufficient detail. In the future, the college plans on holding a webinar that will address best practices regarding employer reports. I will now invite Patrick to explain in greater detail what is meant on the slide by a summary of events that led to the report and what should be included.
Thanks very much, Jeff. So as noted on the slide, of course, we do require the identity of the member in question. This would include a name as well as the college registration number. We also need to know what exactly happened and when did it happen. We require detail with respect to the incident or incidents. Please refrain from using generic language or standardized text and be as descriptive as possible so that we're able to get a sense of the severity of the matter. Please indicate specifically what action was taken in response to the matter. So if there was a suspension, please indicate the length of the suspension. As well, if the matter involves students, please state their please state their ages and grade levels. Please note any relevant prior concerns. Often employers will attach a copy of a disciplinary letter that has been given to the member in their report to the college. This is helpful because it often provides the detail that we are seeking. Thanks very much, Jeff.
Thank you, Patrick. How to submit a report. By email at ih@oct.ca, which is the preferred method, by fax, the number on your screen, or by registered mail or courier. And again, if you have any questions at this time, please send them to our questions tab. If the matter moves forward to investigations, you will receive a letter and a checklist asking for further information. You are required to provide the college with all documentation relating to your report within 30 days of submitting your report to the college. We suggest you start assembling the information following your report to the college to meet the 30-day timeline. If the information is not received within 30 days, the Director of Investigations and Hearings or the Registrar may contact the Board's Director of Education. Now let's do a quick review of the documents required by the college following an employer's report. The college requires information and documentation pertaining to a member's previous disciplinary and conduct issues.
Jeff, what would such information typically include?
Good question. All underlying information and documentation, such as principal, vice principal's investigation notes, witness statements or notes, investigation findings, disciplinary letters, etc. The college also requires the member's current employment status, the names, addresses, and contact information for school and board staff who are involved, and those of any affected students and student witnesses are also required. Please do not send redacted documents. For TPA matters, the college will require a copy of all of the most recent summative reports for the member and materials, such as the principal's observation notes. Where there is a criminal matter, the college requires information such as what the member has been charged with and or found guilty of, upcoming court dates, and any court documents that you have obtained. You may wish to go to the employer's area, that's the portal on the college website, that provides further information concerning board obligations. Also, most of you should be aware of our checklist that you receive, which sets out what documentation the college is requesting from you. If you are not familiar with the checklist, please send us a note on the questions tab, and we will get back to you with this information.
We do have a question, and it's, is there a specific template for use by the employer for reporting? If not, is a narrative style report sufficient?
Hi, thanks for the question. This is Patrick again. We don't have a specific template that we provide to employers for reports to be submitted to us. Some of the larger employers in Ontario have created their own templates that they use. However, a narrative or letter format is perfectly acceptable. And if we do require further information that's not submitted, we will, of course, follow up with you in order to obtain that information.
We have another question. Do we receive confirmation of email receipt from the college?
Hi, thanks. I'll field that question as well. There is no current automatic confirmation of email receipt. The initial confirmation would occur when we follow up with you to notify you as to whether the matter is moving forward or not. If you would like to follow up with the college before that point, though, please feel free to get in contact with us.
There's a concern that email is not secure and that this is sensitive information to send in an email.
The college's email servers are secure and all emails are treated in a confidential manner. If there are concerns from the employer with respect to security of email, we do accept hard copies of documents as well. I would certainly suggest sending them in either by courier or by registered mail to ensure that they are received here, but we will accept hard copies of documents if that's preferable for the employer.
We have a question about restriction of duty. Does it include a board placing a teacher on paid leave pending the outcome of a CAS investigation, or only following completion of the process depending on the outcome and findings of the process?
An assignment to home pending any sort of investigation is not typically considered a restriction of duties for reasons of professional misconduct and would not immediately trigger a reporting requirement to the college. That being said, if there is particularly in cases where there is a lengthy assignment to home We do recommend that it is reported under Section 43.3 of the Act, but strictly speaking, under Section 43.2 of the Act, it is not a restriction of duties for disciplinary reasons.
A similar question, but I want to make sure that we're answering them all. If a teacher is assigned to a paid leave of absence during the course of an investigation, for example, Children's Aid Society investigation or conduct investigation, is the employer required to send the report, the paid leave, to the college, or only outcomes of the investigation if discipline is issued? Or if there is a CAS verification.
Sorry, yeah, just to reiterate, a paid leave of absence or an assignment to home pending a board investigation or a CAS investigation does not require immediate reporting to the college, unless there is a resignation or retirement during this investigation. That would trigger an immediate reporting requirement. But apart from that, the outcome and the subsequent disciplinary action, if applicable, is what would trigger a reporting requirement under Section 43.2 of the Act.
Are boards obligated to let the member know that a complaint has been filed with the college?
Yes, employers are required to notify members when a report is submitted to the college, and to forward any documentation that is submitted to the college to the member themselves.
Right, I just wanted to go back to something that Jeff was talking about in terms of what we were asking for when you make a report, and to touch upon something that Patrick talked about earlier. We do ask in the checklist for the member's discipline history with the board. And we appreciate receiving, letters of expectation or previous discipline matters that maybe weren't reportable to the college, but we've asked them to be included in the current report. But in addition to those letters, the college would also like to ask the employers to provide the underlying material, if it still exists, with respect to what led to those historic disciplinary measures from the board. So, for example, any handwritten notes or typewritten notes of a vice principal or a principal interviewing a student, for example, or students, that would be very helpful to the college in terms of determining whether those things that weren't previously reported might be the subject of an investigation in conjunction with the current report. And that does tie into something that had come up earlier that I think somebody touched on, that we are planning to do a sort of a practical webinar about what a report would look like when it's made to the college. So that will be upcoming at some point. I'm not sure in this year, but certainly soon.
Would it be possible to get a copy of the checklist? Is it on your website?
Hello, we do have the information that's on the checklist available in our website. If you'll bear with me, I don't remember exactly where. It's within the complaints and discipline section on the college's website, though. I will look that up, and if there is a specific question, please feel free to email me, and I'll provide the full checklists as well, but it is available on the website.
Should boards be sending the member the check sheet and all the materials that the employer provided to the college?
Yeah, I think Patrick may have addressed this earlier, but yes, you're required under the Act to provide the member the same information that you provided the college. Thanks.
Once you've provided all the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the legislation requires that such information be provided within 15 days of the employer receiving the request. Please note that any information you send to the college as a result of the checklist or as requested by the investigator must also be provided to the member, as we just talked about, within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply. I will now address some of the most common questions that the college receives regarding our requests for information. Any relevant audio and visual recordings must also be provided. For example, this would include video recordings of a hallway incident. The college also requires any handwritten notes related to the complaint, such as opportunity to respond meetings and interview notes. Settlement agreements will usually contain a provision indicating that the document can be disclosed if required by law. For example, a legislative requirement, such as that contained in the Ontario College of Teachers Act, is a law that requires this information. You cannot enter into an agreement, including minutes of settlement, with the member, which includes an undertaking that is contrary to your reporting obligations under the Act. For example, you can't agree not to report a matter to the college that is required under the Act. Also, you cannot agree not to continue to provide information to the college due to the ongoing reporting obligations.
Section 47(1) of the Act permits the college to request personal information about members is defined under provincial and municipal freedom of information legislation. Under Section 48(1) of the Act, the college is required to keep such personal information confidential and not to communicate the information to any other person subject to certain exceptions, including the administration of the Act. We're going to pause here and break for questions. Again, if you have any questions about this reporting obligation, please send them to our questions tab.
So we have a question. Can you please speak to the privacy of student information and how this is considered? It was just said that the employer is to provide a copy of what is submitted to the college to the employee. What about student demographic information? What about if the employee is no longer employed and providing student biographic information?
That's a good question. The college, when it discloses to the member, does redact all personal information, in particular in relation to students. So that would include date of birth, address, telephone number, if there was a parental email address. The college would suggest that when you're making a similar disclosure to the member pursuant to the Act, that you would have to undertake to redact that personal, as you call it, demographic or biographical information. Because as we discussed earlier, as Jeff just mentioned, we are required under our Act, under Section 48, to maintain confidentiality with respect to the information received. So the college would suggest that it would be important for the school or the employer to undertake a similar exercise in protecting the student's identity.
If the employer still has access to a letter of discipline that was required to be removed from the employee file due to the collective agreement language, should it be forwarded? For example, a grievance file may contain a copy of the original letter of discipline that was pulled from the personnel file.
That's also an excellent question. It's the college's view that, yes, when we ask on the checklist for the member's discipline history, that you would also forward any letters that would have been removed through the member's discipline file. As a result of, for example, there's often an agreement that if the member conducts himself or herself accordingly for a number of years, the letter will be removed. From the college's perspective, that is an employer issue. Perhaps an employee issue, and it doesn't exactly fall, it wouldn't necessarily be the college's perspective as to how it would deal with the discipline history.
Do copies of the audio and video evidence need to be sent to the member with the report?
Again, another good question. Yes, anything that you've disclosed to the college would also have to be disclosed to the member. That would include audio or video. Sorry, Kathy, I'm just going to add one thing. Chantel's just noted, and it's a good point, that if the matter is forwarded to discipline, or even in investigations, we're going to disclose all of this information to the member anyway. So it is a requirement under the Act. The employer also do it, but during the investigations process, we disclose the information, and then at the discipline process, they also, if it goes to discipline, there's also a disclosure requirement there. and any additional information that may have been gathered will also be disclosed to the member or his or her counsel.
Oftentimes, employees, when facing a workplace or external investigation, will move quickly from an assigned to home status to a medical leave of absence, sometimes for a very long time. Does this change your earlier stated position regarding our duty to report?
Thank you for that question. Strictly speaking, if an individual goes on medical leave while an investigation takes place, there is no requirement in the legislation under Section 43.2 of the Act to report that matter to the college. That would only be triggered if the individual resigns or leaves their job, retires, or quits. However, Section 43.3 of the Act allows the board or the employer to report a matter to the college should they believe that this should be addressed by a committee of the college. So, although Section 43.2 does not directly address medical leaves of absence while under investigation, either by an employer or by an agency such as CAS, the employer still does have the opportunity, and if the employer believes that this matter should be forwarded to the college, it should be forwarded at that point.
So a question about sending video. What if the video has images of other staff or students? Would that not be a privacy concern?
So perhaps I didn't give a very nuanced answer. I think that when maybe that should be assessed on a case-by-case basis. And you may wish to contact, I'm the manager of investigations, you may wish to contact me to discuss that issue if that comes up in terms of you think that there may be a privacy concern.
And a related question, if there is a student in the audio or video file, should this be redacted as well when provided to the member?
Again, I think that would have to be determined on a case-by-case basis, because I understand the thrust of the question, but it may be that it would have to be determined on an individual case basis.
The Ontario College of Teachers Act specifies that the college can require employers to send personal information to the college as defined in the Municipal Freedom of Information and Protection of Privacy Act and the Provincial Freedom of Information and Protection of Privacy Act. These two privacy acts define personal information as including information relating to the education or the medical, psychiatric, psychological, criminal, or employment history of the individual, or information relating to financial transactions in which the individual has been involved. Therefore, if you have medical, psychiatric, or psychological reports relating to the concerns which prompted you to notify the college, these must be disclosed as part of your duty to report.
Just to pick up on what Jeff just said, the investigation committee will require medical, psychological, psychiatric information in order to determine whether the matter before it should be referred to the Fitness to Practice Committee. This information may include medical, psychiatric, and psychological reports, as well as any documentation relating to a member's application for short or long-term disability relating to the member's capacity to teach. Should the matter be referred to the Fitness to Practice Committee, it will require the same information in order to determine the matter before it. If you're in doubt whether the member's conduct raises fitness to practice issues, report the conduct as professional misconduct. The investigation committee can always redirect the matter to the Fitness to Practice Committee if required. There are some proposed amendments to Section 26 of the Act, which will outline the powers of the investigation committee to make inquiries into a member's capacity, including the power to require a member to submit to a physical or mental examination. That information would subsequently be considered by the committee in determining the matter. In 2018, the college's investigation committee referred 15 matters to the Fitness to Practice Committee. In the interim, the committee also has the power to suspend the member until he or she submits to the medical examination. If the committee has reasonable and probable grounds to believe that a member is incapacitated, the committee could make an order directing the registrar to suspend the member's certificate of qualification and registration until the member undergoes the medical assessment.
We just want to stress that those amendments have not been enabled as of yet, and so they're not functional. The investigation committee does not have the capacity to order this as of yet, but it will be enabled probably at some point.
If you look at the slide that's currently on the screen, the resource from which this slide originates is available by contacting Janice, the Manager of Investigations. It's a quick reference of do's and don'ts on submitting information to the investigation committee regarding matters related to incapacity and fitness to practice. Now, at times, employers redact information such as student names and contact information. I can clarify that this redaction is not required. Please send the college unredacted documents. Please do not send password-protected documents to the college. As I believe Patrick previously mentioned, the college email system is secure and confidential. And also, please do not send illegible documents. Now, please note that the timelines specified in the Act remain the same regardless of your academic calendar or closure period.
Jeff, what about if there's an ongoing grievance or an arbitration for the member?
The legislation does not allow the college to delay an investigation when there is an ongoing grievance or arbitration.
We're now going to turn to a few frequently asked questions relating to the employer's duty to report. As I'm going through them, you may note we've touched on a few of these issues earlier when we were responding to some participant questions. The first one being, do I have to report when an employee goes on a medical leave of absence? In and of itself, no. An employer's reporting obligation under Section 43 of the Act are triggered due to a suspension, a restriction of duties, or termination of a member's employment for reasons related to professional misconduct. Therefore, where the member goes on a medical leave of absence in the course of an investigation, if you're uncertain whether the member's conduct constitutes professional misconduct, report the matter to the college. The second question, if an employee goes on a medical leave during a board or school investigation regarding their conduct, am I required to report this to the college? And as we mentioned earlier, and as Patrick alluded to, yes, as this may have relevance to how the investigation committee chooses to deal with the member. For example, referring the matter to the Fitness to Practice Committee. If you have any questions following the webinar, please feel free to contact Patrick Winter. And the information is before you on the slide. You can contact him by email or by telephone.
Thanks, Adele and Jeff and Patrick and Janice for sharing all this information with us. I'll now ask the registrar, invite him to conclude the formal session of the webinar and invite participants who wish to remain online to share their questions verbally or submit their questions to the questions tab. Michael?
Thanks, Chantal, and thanks very much to our staff presenters and to all of you for your participation and for your questions and an interest in the work of the college. As we've mentioned, we're going to remain online to discuss and answer any questions for those of you who are interested. If you'd like to ask a question, please feel free to raise your digital hand. Just going to adjust my microphone here. Apologies for any feedback. The PowerPoint presentation that we've used can be downloaded from the Handouts tab on your control panel. The presentation will also be available on the college website in the very near future, and it will be digitally transcribed. Lastly, we do have an online survey on the GoToMeeting platform. We're always interested in feedback on continuous improvement, but also for suggestions for the future. So feel free to complete the survey. Feedback, which you're hearing now through my microphone. The pun isn't lost on me. Please feel free to complete the survey, as your feedback is important to us and will assist in planning future webinars. And so with that, we'll open it up to questions. And I think Kathy's indicating we have some, so thank you.
So there's a question, is there a plan to share this web conference for teachers for training and information purposes?
To date, this will be available on the website at a future time. That's an interesting question, and I'm sure that we can consult about that and see if that could be a tool made available to teachers for educational purposes.
A comment received, the timely and supportive responses that I've received from the college's intake and hearings investigations team members has been exemplary in every instance. Thank you for your leadership in this important work. And thank you very much for that comment.
That was very kind. Thank you.
So another question, when days are referenced, are they calendar days or school working days?
Sorry, when the days are referenced, it's calendar days, including weekends.
So there was a request to show the slide with the contact info, so I've got that up for Patrick. And I'll leave that there. But when the discipline committee places restrictions or requirements on a member, how does the college inform a board when these requirements have been met?
So we don't have anyone from our team from the hearings office. We do have a hearings coordinator, and so it would be per a notation. So notation on the college register, public register, would indicate if the restrictions or the terms or conditions that have been imposed. Once they have been completed, that notation would be removed. As such, you would not see those restrictions on the notation. However, you could always contact the college if you had any concerns or were inquiring on that fact.
Can you post the checklist referenced in the handouts for us to print? Thank you for your consideration.
Hi, thanks for the request. So as this presentation's been going along, I figured out a quick way to get you to the checklist on the website rather than providing sort of follow this link, follow that link. If you just type checklist into the search function on the main oct.ca website, the second link that comes up will be titled Duty to Report, and that will have a full outline of all the checklists. There are different checklists depending on what type of matter is reported to us, and it'll go through all of those in detail. Do keep in mind that the checklists that we send in our requests for further information are tailored to your specific report. So depending on the type of report that's sent to us, we will be requesting different information, and also depending on what information is sent in an initial report, we will either add or remove items as necessary. But to access the checklist quickly, type checklist, one word, into the search function and click on the second link titled Duty to Report.
So we want to thank everyone for their participation, whoever's still online with us. Thank you very much. Excellent questions. I just want to thank staff again for putting this together, and we look forward to holding our next webinar. And please, through the survey, we'll take your feedback on what that webinar should include. Thank you very much for your time today, everyone.